My spouse owns a business. How is it valued in our divorce? Dividing marital assets is always complicated, but the challenges intensify when the asset in question is a business. In New York, a company isn't just another line on a balance sheet. It represents income, identity, and future opportunity. Courts consider not just how to split property but whether a business is part of the marital estate. If your spouse owns a business and you are facing divorce, working with an experienced Manhattan divorce lawyer is essential. Under New York's equitable distribution law, property division aims for fairness rather than a strict 50-50 split. Judges begin by classifying each asset as marital or separate property. Marital property includes assets acquired during the marriage, while separate property covers items owned before marriage or received individually. A business that grows in value during the marriage because of a spouse's efforts can shift from separate to marital property. Growth due to passive market forces remains separate, but active involvement, running operations or supporting the company, makes that increase part of the marital estate. Mixing personal and business funds may also convert separate property into marital property. Once a court determines that a business is marital property, it must decide its value. This process relies on financial experts and documented evidence. The default valuation date for an active business is the date the divorce action is filed because that is when the economic partnership effectively ends. Courts may choose a later date if major events between filing and trial significantly alter the company's worth. Forensic accountants review tax returns, profit and loss statements and other records to uncover the company's financial condition. A critical step is normalization, which removes personal expenses and other non-business costs to show the company's true earnings. Adjustments often include adding back excessive salaries, personal vehicle or travel expenses, and one-time transactions. Intangible elements can be just as important as balance sheets. Enterprise goodwill, the value derived from a strong reputation or loyal customers, is treated as marital property if developed during the marriage, while personal goodwill tied to the owner's personal relationships is rarely divided. Professional licenses and degrees obtained during the marriage were once valued as marital assets, but New York law changed in 2016 to eliminate direct valuation of enhanced earning capacity. Instead, courts now consider the supporting spouse's contributions when distributing other assets. After the business is valued, the court decides how the non-owner spouse will receive their share. The most common solution is a buyout. The owner keeps the company and pays the other spouse through a lump sum or structured installments. If cash isn't available, courts may offset the non-owner's share with other marital assets of equal value, such as the family home or retirement funds. Selling the business and splitting the proceeds is a last resort because a forced sale can disrupt operations and depress value. The law office of Richard Roman Shum, Esq., is a law firm led by a lifelong New Yorker with more than 15 years of experience in property division, business valuation, and asset protection. He approaches each case with calm strategy and compassion and understands the practical and emotional challenges of high-asset divorces. Divorce cases involving a company are complex, and how your spouse's business is classified and valued can shape your financial stability for years. The law office of Richard Roman Shum, Esq., is committed to guiding clients through each stage of this process. If your spouse owns a business and you are contemplating divorce, consult a knowledgeable divorce lawyer and attorney to protect your interests. Contact the law firm at 20 Clinton Street, FRNT 5D, New York, New York, 10002, or call 646-259-3416 to discuss your case.